Next, we have to make sure our complaint contains a legal theory of recovery or a legal cause of action. If we fail to state a legal theory, whether it be negligence, breach of contract, defamation, divorce, whatever type of case it is, again, that would open up defendant to come in and challenge and have our case dismissed. So we have to make sure that we can allege these elements. So when we were talking the other day about negligence and the four elements of negligence, is because we have to make sure in our complaint we actually allege those four elements of negligence. So first we have to allege the facts of the case, which is our client's story, our client's version of events, what happened. And then we have to make sure that we pull those facts into the legal theory and show that defendant had a duty, defendant breached that duty, and defendant caused plaintiff's injury. So we always have to have a legal theory. You will at times have clients that have very sad stories, have very sympathetic stories, have very unfair stories. They don't always have a legal cause of action. So we have to have that in order to be successful in court. At the end of the document, there has to be what is called a verification. Pennsylvania has verified pleadings, which means that the party who is filing the pleading must sign the document under oath that everything in the document is true and accurate to the best of their knowledge. So it's basically, it's just a statement of oath. It's a perjury statement, basically. And so if we're representing plaintiff, the complaint has to be verified and plaintiff has to sign off on the document. If we're representing defendant, the answer or their counterclaim also has to be verified. So our clients do need to sign these documents. The attorneys will also sign them, but clients are the ones that are verifying that everything in the document is true and accurate to the best of their knowledge. And so that goes at the end of the document. A couple other important pieces that we will be looking at this semester and more so next semester is the fact that we can incorporate by reference other documents. So personal injury, probably not such a big deal, but say you're doing a lot of contract work or business litigation, and a lot of the cases are based on writings. The rules allow us to incorporate by reference these documents, so we don't actually have to rewrite anything. So for instance, if you wanted to say the parties entered into a contract on January 1st, 2018, and you wanted to attach a copy of the document as an exhibit, you can do that under the rules. And you could just say a true and accurate copy of the contract is attached hereto as Exhibit A. And then you would label the document Exhibit A, and you would attach it to the back of your pleading, and you could file it with the court. And so we will be using that in several of our assignments this semester, next semester, because it is something that we do see frequently in practice. The other thing to keep in mind, and this is also important when we are talking with our client in that initial interview and starting to develop the case, is we have to remember that we have to bring all claims arising out of this event or transaction in one pleading. We cannot bring them in separate pleadings. If so, res judicata will bar them from being brought later. Res judicata, just as a refresher, it means the thing has been decided. It is the civil form of double jeopardy, for lack of a better explanation. So say we have a case against defendant and we think there's both a negligence claim and a breach of contract claim. So we file a complaint on negligence, that case gets resolved, and then we file a complaint on breach of contract. And defendant's going to come in, file a response to our complaint, and basically ask the court to dismiss it because of res judicata. The court has already decided this issue between these parties because they arise out of the same event or transaction. So when we're talking to a client and when we're gathering information, we have to make sure that we have all the possible causes of action and bring them all together in that one complaint. Otherwise, we will likely be barred and not be able to bring them later. Same thing if we're representing defendant and we have a counterclaim against plaintiff, we have to bring all claims arising out of that same event or transaction, or res judicata will bar us from bringing them later. So it is very important that we make sure that we have everything we need and are litigating all the issues related to that event or transaction between those parties. And so that is it for now. We will continue with this after spring break. And so I hope everyone is having a good break, and I will see you on the 13th.